Well, good morning, everyone. It's Wednesday. We love Wednesdays because we get to do civil procedure, and you know, this is class number 15, I think. That means you're more than halfway done this semester, right? And then, therefore, almost halfway done with law school. Isn't that exciting? And what do you have to look forward to when you get into... Let me finish my question. Wow. Where you'll be after a couple of years of this.
Debt, that's what we have to look for.
Yeah, that's true, yes. But also being able to pay off that debt with stuff like this.
What? What? Explain.
Hold on.
And the device used to record information from your computer system onto the master CD is a device within the recorder's office. Is that correct, as opposed to being in some other building somewhere?
Yes.
During your tenure in the computer department at the recorder's office, has the recorder's office had photocopy machines?
Objection.
Any photocopy machine?
When you say photocopy machine, what do you mean?
Let me make sure I understand your question. You don't have an understanding of what a photocopy machine is?
No, I want to make sure that I answer your question correctly.
Dave, I'll object to the tone of the question. You make it sound like it's unbelievable to you that he wouldn't know what the definition of a photocopy machine is.
I didn't ask him to define it. I asked him if he had it.
When you say photocopy machine, what do you mean?
Let me be clear. The term photocopying machine is so ambiguous that you can't picture in your mind what a photocopying machine is in an office setting?
I just want to make sure I answer your question correctly.
Well, we'll find out. If you can say yes or no, I can do follow-ups. But it seems if you really don't know in an office setting what a photocopying machine is, I'd like the Ohio Supreme Court to hear you say so.
I just want to make sure I answer your question correctly.
There's different types of photocopiers, Dave.
You're speaking instead of... You're not on your own. This guy is.
I understand that, but I understand what his objection is. You want him to answer the question. I don't think it's fair.
It's not fair.
That's not a fair question. A photocopy machine can be a machine that uses photostatic technology, that uses xerographic technology, that uses scanning technology.
I don't care what kind of technology it uses. Has your offices... We don't have technocrats on the Ohio Supreme Court. We've got people like me, general guys
Objection.
or gals. I'm not really very interested in what the technology element of it is. I want to know.
That's what's at issue in the case, Dave.
Not in my judgment. Do you have photocopy machines at the recorder's office? If you don't know what that means in an office setting, please tell the court you don't know what that means in an office setting to have a photocopy machine.
I would like to answer your question to the best of my ability.
I'm asking you to answer that.
So if you could explain to me what you mean by...
I'm not going to do that because I want to establish on the record that you really don't know what it is. I want to establish that. Now, do you know what it is or do you not know what it is? Do you understand what that term means in common parlance or not?
Common parlance?
Common language.
I'm sorry. I didn't know what that meant. I understand that there are photocopy machines, and there are different types of them, just like there are...
Are there
different
any in the
parts.
recorder's
Some of them are
office?
under gas power, some of them under electric power, and I'm asking if you could help me out by explaining what you mean by photocopy
That's
machine.
a great point.
Instead of trying to make me feel stupid.
If you feel stupid, it's not because I'm making you feel that way.
I
Objection!
have self-confidence, and I have no problem.
I don't think you're stupid.
I think I don't have any problem answering the question.
I think you're playing games with me.
Dave, the word photocopy is at issue in this case. And you're asking him whether something is or isn't a photocopy machine, which is a legal conclusion.
This isn't a patent case. There's no statute that defines where I'm asking him to define technology for me. I'm asking, I want to find out from a layperson's perspective, not from an engineer's perspective, not from a technician's perspective, but from I have an idea. How about this? Have you ever heard the term photocopier or photocopy used in the recorder's office by anybody?
Photocopy? I'm sure in the time I've been there, someone has used the term.
Have you ever heard them use it in referencing a particular device or machine within the recorder's office? By way of example, can you photocopy that for me? That's an example of office parlance.
That particular terminology I've not witnessed.
What was the context that you heard the term photocopy used in the recorder's office?
I'm sure it's been used. I didn't say I remembered a specific instance.
All right. But you have a general understanding that people have used the term photocopy within the recorder's office in terms of something that could be done there. Is that true?
I'm sure it's been used. I don't remember a specific instance or how it was used. I'm sure it's been used.
And is it fair to say that it's being used in terms of being able to copy one piece of paper onto another piece of paper using a machine? No? Not sure of that?
I'm sure it's been used. I don't recall a specific instance in which it was.
Do you have a secretary?
No.
Does anybody there have a secretary?
Yes.
Have you ever heard a secretary use the term photocopy?
No.
Have you ever? Do you have machines there where I can put in a paper document, push a button or two, and out will come copies of that paper document also on paper? Do you have such a machine?
Yes, sir.
What do you call that machine?
Xerox.
How did you find that?
That's real?
Enjoyable? Did you like that?
I have several questions.
If you really like that, good news. You're going to love being a lawyer and doing civil litigation. Yeah, that's a real transcript. Obviously being read in a dramatic fashion, but it is a real transcript of a deposition. How many of you have ever attended a deposition? Oh, a bunch of you. Right? So you kind of get basically what happens. You put a witness under oath, and you ask them a bunch of questions. Okay. And it is a discovery device, just like all the other discovery devices that we've been discussing for the last couple of weeks, right? It's just a little bit more informal and a little bit more open-ended, and you have more of an opportunity to catch a party or a witness saying something stupid in an uncontrolled environment than you would on a written document like an interrogatory or a request to produce. But it's basically the same idea, right? Who do you get to depose? Well, bottom lining the rules, you can depose pretty much anybody as long as they're within 100 miles of you. Okay? You can depose people that aren't within 100 miles of you by agreement or by other processes that are beyond the scope of what we're going to talk about today. Basically, there is a way that you can get just about anybody's deposition, especially if you're willing to travel a little bit. There are some limitations on that. There are some people that are listed, types of people that are listed, prisoners, under 38-2. You rarely run into that sort of thing. But you have to get a court order for that. Usually not a problem. Noticing these depositions, right? There is a notice on page 527 of your book. That's a pretty standard type of notice. I have one here somewhere that I'll show you in a Kentucky state court, right? A notice to take deposition is different from a notice motion order, right? You don't ever appear in front of the court when you're sending the notice to take deposition to the other side. This just goes to the other side, okay? So you tender that notice to take deposition to the other side. Whoever else is on the case, all the other lawyers that are on the case, or all the other parties that are on the case, say, listen, I'm going to take this deposition on such and such day. This is a super simple format, right? The kind that you would commonly find in a state court deposition. You can file it with a court, but you don't have to. Again, most of this discovery stuff happens in between the parties, and the court is never involved. Right? The judge says, the day and time, where it's going to be, who the opponent is, who the witness is, and a copy goes to opposing counsel, and usually you'll see a court reporter copied on these too, okay? But the notice goes to the court reporter, so the court reporter knows when and where to be and who's being deposed, okay? You can, and the thing that doesn't really get addressed in the federal rules and isn't really addressed in your book, but is a super basic element of practice, is that you don't just go, in most cases, you don't just go sending out notices for whenever and wherever you feel like it for these witnesses. And in a lot of places, there are local rules that cover this, right? That you have to confer with the other side before you just issue a notice and say, here's where the deposition's going to happen. It is not a cool thing to do that, even if the rules, your local rules, permit you to do it. You need to confer with everybody and say, all right, everybody's got busy schedules. You're going to be lawyers. You're going to have a lot to do. And so you need to get everybody on the same page and say, can we all attend at this day and time? And if everybody says, okay, then you issue your notice. Do you have to do it that way? Well, unless the local rules say so, no. But as a matter of professional reputation, you want to do it that way. Take these in front of court reporters. Well, we know that, right? The woman that you just saw in the video that's sitting there typing and taking everything down, that's your court reporter. Do you have to? Not everywhere. You can, and I think the rules, the federal rules contemplate too, that you can just take a video deposition. But you do have to notice, you have to put that in the notice if that's what you're going to do. Be careful about, in 30G2, and again, this is one of those things that I'm sort of cautious about because, you know, best practices are if you're going to depose a third party, you need to issue a subpoena along with that notice of deposition to that third party, right? Somebody that's not involved in the litigation, somebody that's not a named party to the litigation. So you want to just depose a witness that was there at Wix that night when it happened, but somebody who's not suing or being sued, you need to issue a subpoena, and the reason you need to issue a subpoena is because of 30G2, which basically says, if you notice a deposition, everybody shows up for that deposition, and you haven't subpoenaed the witness, the deponent, and the deponent doesn't show up, then you can be on the hook for paying attorney's fees and expenses and all that good stuff. And you don't want that. Now, I hasten to add that in common practice, you don't always see these subpoenas being issued for every single deposition. If somebody's agreed to be there, you can usually know that they're going to be there. But best practice is issue your subpoena. There's a difference too, we discussed this briefly, there's a difference too between a discovery deposition and a trial deposition. And what you'll commonly see in Kentucky is if somebody is not available for trial, you can notice their trial deposition in advance of trial. And you show up and you basically, it is a little bit more of a controlled environment than a discovery deposition because as you've probably gathered by now, you haven't seen a deposition. Discovery depositions tend to be kind of anything goes, kind of open-ended, and you can ask whatever you want. And you want to get the witness talking, and you want to cover lots and lots of stuff that you would not only not be able to cover in trial, but probably not want to. You're not really constrained so much by the rules of evidence in these depositions. They're for the purposes of discovery, if it's a discovery deposition. Right? If you're asking open-ended questions, you want the witness to talk, you want to get as much information as you can, so then you can go back and find out all the other stuff about the case that you didn't know before you took that deposition. What can you ask? Well, like I said, pretty much anything. Pretty much anything, with a few exceptions that we'll get into, but mostly the same stuff that has been governed by 26B this whole time that we've already discussed in the context of interrogatories and requests to produce and requests for admissions and all these other wonderful discovery devices that we have. Okay? You can't ask for stuff that's irrelevant, and you can't ask for stuff that's privileged. If you've been at this long enough, you can make just about anything relevant, right? Especially in a discovery deposition. So really the big thing, if you're defending one of these, the big thing that you perk your ears up for is anything that is privileged. That's where you have to dig in your heels and instruct your witness not to answer the question. What did you discuss with your attorney last night? Don't answer that question. When you instruct your witness, your client, not to answer the question, because that invades privilege. Talk about that more in a minute. You can't go longer under the federal rules than 7 hours without a prior agreement between the parties or without leave of court. Are you thinking, is it possible to go for longer than 7 hours in a civil deposition, a discovery deposition? Oh yes. Oh yes. Yeah. You could go a couple of days with a named party. If you have a whole bunch of extra time on your hands, you can go to YouTube and watch the Alex Jones depositions that last a couple of days. Okay. But the rules limit you to 7 hours. And you should, before you take one of these, get a feel for what they're like. I mean, you'll probably, hopefully you'll have the opportunity to sit in on a whole bunch if you actually go into civil litigation. You'll have an opportunity to sit in on a whole bunch of these before you actually take one. But at least go and watch the videos so you sort of get a sense of the pace of the thing, the rhythm, the timing, the kinds of questions that are typically asked in your jurisdiction, and what is off limits. Jessica?
This is just a question. Let's say that there is like a certain sort of deposition that you split up over several days, like with Alex Jones. Do each of those days count as one individual deposition, or do they group it all together as one?
No, it'll usually be grouped all together, and you get one massive transcript that covers day 1, day 2, day 3. It depends on how the court reporter does it.
Okay, and then
If I understand your question, I mean, it doesn't matter to the court. You know what I mean? Formally speaking, it doesn't really matter to the court. So you'd have deposition volume 1, deposition volume 2, and it's broken up like that.
Okay.
Yeah. Anything else? What can't you ask? Or, a better way of thinking about it is, what can you object to? Because again, if you're taking the deposition, as long as you're careful not to ask about matters of privilege, it's pretty much anything goes, right? If your questions are not designed to embarrass or harass a witness, and of course none of you would ever do that, in a discovery deposition, you can pretty much ask whatever you want as long as you're not asking for privileged information. You can also object all you want, right? There's limitations to that. Objecting is one thing. We'll talk about some proper objections, and I sent you that document, and everybody get that document that I put up on Blackboard about proper objections. That's a fun thing to read, and I think it's helpful. Because I think when you first go into these, you'll probably be defending some of these depositions before you take them, if you're a civil litigator. And so the question is always, all right, should I speak up here? Should I object? Should I instruct the witness not to answer? Usually, you don't instruct the witness not to answer unless, again, you've invaded, the question is seeking to invade some privilege. You can object pretty much whatever you want, and if you instruct the witness not to answer and then get crossways with the other side, you can stop the deposition to get the court order. And the language of the rule is a little confusing because it says you can make a motion to terminate the deposition. You're like, well, how do I make a motion to terminate the deposition? We're just sitting here in a conference room. With a court reporter, and I don't have anybody to make a motion to. We talked about this briefly before. You can go get the judge on the phone. You can go get a judge on the phone. You can't get your judge. Yeah.
Two questions, and I think you kind of was saying this, but I wanted to clarify. So, like, similar to when we did the interrogatories, and we kind of said, I object, but, you know, go ahead and answer. Would you do that same type of thing here?
Yes.
Okay.
Yeah. So your objection, yeah, no, it's a good question. When you make your objections, you're not instructing the witness not to answer. That's really important. Okay? There's a difference. Okay? There's a difference between drawing that line in the sand saying, no, 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 you're not going to answer that question, which generally you're only going to do if the question is asking for some kind of privilege. What did you talk to your attorney about last night? Don't answer that question. Okay? That's simple. That's straightforward. Everything else is objection, you can go ahead and answer. Make the nature of your objection clear on the record. Yeah.
I did one, or I attended one deposition this summer, and I never found out the answer to this. They stopped it after like 3 hours because the attorney asked, when did you first meet with your attorney? And that was like relevant because it was an injury case.
Mm-hmm.
And the attorney was like, don't answer that. And they stopped the deposition. I never found out if the attorney was right to say that that was privileged.
Yeah. That's going to depend. Yeah, it's going to depend on the case law and the jurisdiction. I don't actually know what that is in Kentucky. I've never run into a situation where somebody has shut down a deposition because of that kind of question, but I certainly understand why it would happen. Here, what he asked, the question was, when did you first meet with your attorney? I think that's a fair question. You're not asking to invade attorney-client privilege. Of course, the Kentucky Supreme Court may disagree with me, but I doubt it. You're not asking to invade attorney-client privilege. You're saying, when did you first sit down with an attorney? Is that privileged information? I don't think so. But it's certainly, I think it's certainly objectionable. At least you should make that objection known. That you instruct the witness not to answer. And if you instruct the witness not to answer, and the other side wants to shut down the deposition because that question is so important to the substance of the deposition that we're just going to shut this whole thing down until I can't imagine a situation in which that would happen. But lawyers get petty sometimes. But,
So I was asking myself, like, what would happen if, you know, you're representing the client and, like, things are kind of, I guess you feel like they're bad or you feel like they're kind of out of control or something, but you don't know exactly what to do. I guess in that instance, could you maybe call for a break or something like that and, I don't know, like, consult with your client privately or like maybe
Sure.
call a partner or something?
sure. Yeah, no, you can call a timeout pretty much whenever, as long as there's not a question I think that usually the other side will get kind of grumpy about that. As long as it doesn't run afoul of some kind of local rule or other court order, you can say, let's take a break in the middle of questioning, as long as there's not a question that's on the table. Okay? Wait for your client or the witness to answer that question, and then take your break, go out in the hallway, confer. If it's your client, there's nothing, they still can't invade that privilege, even during the deposition, right? And so, yeah, you can phone a friend, and you can use your sort of whatever get out of jail free cards that you've got. Typically, 30B3 lets you shut it down if things are going really badly. I've seen this happen very few times. Okay? You mostly don't want to do that, because if you do that and you screw it up and you waste everybody's time with that, then you can get hit with expenses and attorney's fees and all kinds of other stuff. Right? There is a fundamental difference too, and this is a little more subtle, and you will get more into it if you take trial practice, and you'll get more into it in evidence too. But there's a difference between asking questions in a discovery deposition and cross-examining a witness. Okay? So when you are asking questions in a discovery deposition, or for that matter, when you're asking questions of a witness on direct, in a direct examination, You want the witness to tell the story. You want that witness to talk as much as possible so you can discover more things. You're in the process of discovery, right? What did you see when you went through the intersection? That's a question that prompts a witness to talk, right? You tell the story. You talk. I want you to talk about this as much as you possibly can. Well, I saw some trees, and I saw some birds, and I saw a stop sign that I blew right through, and I saw some lines on the road for a minute, and I saw the pavement. That's different from a cross-examination question that I somehow cut off on my slide, but you get the point. You saw a stop sign, didn't you? But you didn't stop for it, did you? Right? A cross-examination question is essentially you testifying, you making the points, right? You're making the points that you want to make and just getting your witness to say yes, no, yes, right? It's different. You don't want that in a discovery deposition. You want to keep them talking, right? Because then you can lull the witness into a false sense of security for when they're on the witness stand at trial, and then cross-examine, right, based on their prior testimony. You already know, because you asked this question in your discovery deposition, that they saw a stop sign. So you know the answer to this question when you ask it in cross-examination. Right? Does that make sense? What kind of objections can you make? Objective form is super common. Is the question confusing? Is it badly worded? Is it compound? Compound is really sort of a subspecies of objecting to form. But you could object and say, oh, there's an objection, that question's compound. If you have a witness that's smart enough, they'll listen to that and say, oh yeah, that was really two questions rolled into one. Sometimes these objections are for your client too. Object to form. Now client, if I say object to form, perk your ears up, because maybe that question was confusing, and maybe you should listen to it a little closer, and maybe you should really think about how you answer that question. If I say objection calls for speculation, you might really think about whether or not you can answer that question as a matter of fact, or if you're just guessing at it.
Is it against the rules to say that before to your client? Like
No.
something I say.
No, not in this country. Not in this country. Preparing a witness for a deposition, as I understand it, or preparing a witness for testimony, as I understand it, in some countries, like the UK, is a big no-no. But you must do it here. You must do it here. Is it malpractice to not prep your client for their deposition? Maybe not, but you sure as hell should do it. Right? At least send something that is along the lines of the letter that I stuck in your materials on Blackboard that says, here's what you can expect out of this deposition. But you also should tell them, if I make an objection, perk your ears up. Just like ask and answer. This sends a message to your client. And the message is, bonehead, you already answered that question. Don't answer it a different way this time. Okay? Because will your client answer the same question two different ways in deposition? Yes, inevitably. That will happen. Okay? At some point in your career. And of course, again, if the question is just designed to embarrass or harass a witness, you can shut down the deposition, but you've got to be cautious about that. And again, it doesn't happen very much. But then in a jurisdiction like Kentucky, where courts rarely award sanctions or attorney's fees or expenses, is it that big of a risk? I don't know. All right, questions about any of that stuff? Good here, right? The example of an improper objection, a sort of classic speaking objection. Remember that video that we watched at the beginning? And the deposing attorney says, you're not under oath, talking to the other lawyer. You're not under oath. We're not taking your testimony here. I want to know what this guy has to say about it. That, in essence, is a long way of saying, excuse me, counsel, but that's an improper speaking objection. Just saying object to form is one thing. Objection compound. Objection confusing. Okay. But saying objection to form, you're asking the witness two different things here. One is whether he did this really bad thing, and the other one is whether he did it voluntarily. And I don't think he can answer that. I think you need to split that up into two different questions. Because one calls for a legal conclusion, the other one is just, I don't know. Right? So if you get into a big, long objection like that, it's not proper. Right? That's not proper. Is somebody going to shut down a deposition on you? Probably not. Does this happen in common practice all the time? Yes. Right? But only because those lawyers have not had this class and they don't know that it's improper. But you don't want somebody hauling you in front of the court saying, look, they're coaching their witness on how to answer these questions throughout the entirety of the deposition. Generally speaking, you don't want to instruct a witness not to answer if it's a non-privileged question. If you think it's irrelevant, think it exceeds the scope of what they can ask about, fine, but they're probably going to have to answer the question anyway. Remember, this is just discovery. It's way different from trial and what goes on in trial. Everything that your client says or the witness says in a deposition is not going to make it into the trial record. If it does, there's something wrong. Now, if you object to every single question, because that's what your gigantic flagship law firm has taught you to do, every single question, object to form, object to form, object to form, object to form, because you think you're doing some kind of record preservation. That's annoying, and it's possible that you get sanctioned. But don't worry, the appellate court will bail you out. I think that's the moral here. Where you have an Iowa judge sanctioning a Jones Day lawyer for obstructionist conduct during depositions, speaking objections, and then excessively using form objections. I know that's hard to see, but that's what it says. And then using objections to coach the witness on what to say. This judge gets cranky about it, says those form objections are a waste of time, they're not necessary. And this judge has probably seen this kind of behavior from these lawyers, from this law firm over and over and over again, and decides to assess sanctions against the senior partner there to the effect of making her do a video on proper deposition questioning technique. The appellate court later said you don't have to. All right. 30b-6. That's an important one that is touched upon in the case you read for today. And this is when you want to depose somebody, but you're not sure who. This is when you want to depose a corporate representative. So you sued a corporation or a municipality or some other organization. And you say, I don't know who to depose, you pick. Right. to the defendant. You pick. Send me somebody who can testify about the following topic. Here's an example of one of those, right? This is a super detailed one. They don't have to be this detailed, but this one just happens to be. Notice a video deposition. You're taking a capital Y video, you have to say so somewhere, right? It says all the 30b6 language. And what am I looking for? Reproduces the rule verbatim. And somewhere in here, here. This paragraph here says, tracks the language of the rule, and says, attached at Exhibit A is a list of the matters for examination. Okay? So what's happened here is he sent this notice to the police department. It's a standard notice. And then there's an Exhibit A attached to it that says, I need somebody that can testify about all these things. And you're sitting on the other side, you're like, well, we don't have just one person that can testify about all those things. So maybe you designate 2 or 3 people. That's okay too.
You can depose more than one person.
Second?
You can depose more than one person at the same time?
Not at the same time, but successive depositions, right? You might do it all on the same day. Yeah, these can be 30 minutes, they can be 7 hours, they can be 7 days. Just depends on what the witness has to tell you. Yeah.
So will whoever you send this to the police department here, will they tell you, like, we're gonna send this person to talk about 1 through 5, and this person to do like?
Yeah, that usually happens just sort of informally between. I mean, it may not. You may just show up on the day of the deposition and there's 10 people. Usually doesn't happen that way. Elizabeth?
I read somewhere in the reading that you're only allowed to depose 10 people.
Yeah, that's right. Yeah, under the federal rules, you only get 10 without further legal work. That's usually something that's hammered out in your case management plan. And then in the state, I don't think there's a similar state rule.
I guess like when my question would be like if you've got experts in what would be really hard to take fast.
It depends on what kind of litigation you're involved in. Right? But it's usually not a problem. If you need to depose more than 10 people and you go and ask the court, hey, I want to depose 2 more people, or it happens informally again with the other side. It is a rule that is not often paid attention to. Right? Because again, if you're getting along in the discovery process, the court has no reason to get involved. You can always agree to pretty much whatever. But yeah, the baseline rule is 10 people without further legal. If you're doing like mass torts cases or something like that, I can envision cases in which you want to take more than 10 depositions, but I rarely run into that in my line of practice. Okay, let's do this a little bit. I asked for volunteers the other day, and many of you were very generous in volunteering, so many that I actually had to turn some volunteers away, and we still ended up with 2 teams to do this stuff. So let's see. Brittany, I'm going to put you in the hot seat. Morgan, come down right here, and Joe, come right here, please.
I hate it. Think it's easier.
And the scenario that I've
Like
given
roast
them
something.
Might laugh about it though.
is the same as.
Me too.
This, by the way, is the setup that you would have, except you also have a court reporter here someplace taking down everything. I mean, this is not an uncommon way to see these depositions happen if you've never attended one. We could have a deposition right here in this room. happening here is I've asked Brittany to be the defendant in our employee versus Hatfield litigation. She is the beer bottle smasher.
Surprise.
Morgan is going to take her deposition for about 15 minutes. So,
Like 40.
and Joe is going to defend the deposition by making appropriate objections at the appropriate time. If you hear an objection that you think should have been made, or something improper, otherwise improper that happens, throw up your hand and we'll stop and talk about it. Or if you just have questions. Let's see, what else was I going to say? These, you've got a detailed outline for your deposition, which is awesome. You should have that when you're questioning a witness. Don't just come in and think, well, this is a discovery deposition, I can ask whatever questions. Definitely have a very detailed outline. Also, don't be afraid to depart from that outline and listen to the answers. I mean, one of the most common mistakes that new attorneys make is in not listening to the actual answers that a witness gives. So you miss this really good stuff because you're so married to your outline that you got to ask this question and this question and this question and this question. Don't be afraid to go off the rails just a little bit, but not too much. All right, Ms. Greenwell, do you swear to tell the truth, the whole truth, and nothing but the truth?
Wait, am I Leonard or am I as Brittany?
I don't know, whoever you want.
Okay, all right.
Mr. McCoy, you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, you may proceed.
All right, so first, this is just like any other court proceeding. You just got sworn in, so please answer these questions truthfully. Please give me verbal responses. Let me finish the entire question before you give your answer. That way we aren't talking over one another. And then if you don't understand a question, just let me know, and I can either re-ask or rephrase it. So first, please state your full name for the record.
Leonard Marie McCoy.
When you do that preliminary stuff, get a confirmation from her. You know, are we okay on that? Do you understand that you're going to stop and ask me if you don't understand a question? Is that okay? That kind of thing, right?
And then what is your current address?
100 South 1st Street.
And how long have you lived there?
About 5 years.
And do you live with anyone currently?
My mom.
And where have you lived previously?
Previously, I lived at 100 South 1st Street with my wife, but now I live with my mom.
Okay, and why did you move?
My wife found out about my mistress.
And where have you attended school?
School. It's a high school. Male.
And what is your overall level of education? What's the highest degree that you've gotten?
9th grade.
And have you ever been arrested before?
No.
Okay. And then have you ever been the subject of a deposition?
No.
Have you ever been involved in any other lawsuits prior to this case, either as a plaintiff or defendant?
No.
And are you on any medications that would impair your memory or impair your ability to testify truthfully today?
Does Pepto-Bismol count?
No, I don't think it does. Have you ever been treated
Get
for
an
any-
answer from the question. Get an answer for the question. You didn't get an answer. She did not answer your question.
No, it doesn't. So are you on any medications that would impair your memory?
No.
And have you ever been treated for any substance abuse issues?
No.
Okay.
Wait a second, because that is a common thing too. You ask the question, well, are you on any medications that would impair your ability to testify? Well, what about Pepto-Bismol? And that derails you for a minute. You're like, no, I don't care about Pepto-Bismol. You think a witness wouldn't give an answer like that in a deposition? Wait and see.
Although if you don't take the Pepto-Bismol, you
Yeah, God knows what can happen
Necessary.
without your Pepto-Bismol. But she hasn't answered the question, right? She hasn't answered the question. Don't let that witness off the hook. She says, well, what about Pepto-Bismol? No, Pepto-Bismol doesn't count. I'm going to go on to my next question. She hasn't said whether she's on any medication. Anyway, I'm sorry. Go ahead.
And what have you done to prepare for your deposition? Did you review any documents?
Yes.
And what documents did you review?
Medical records.
Have you read any witness statements or seen any evidence prior to this deposition? Objection. Privilege. Free not to answer that.
I'm not going to answer that.
Can you rephrase that question?
Have you, well, it's not about conversation with your attorney, it's about reading witness statements and evidence.
No.
And have you had any conversations with anyone about this lawsuit? Objection. Privilege again. Have you had any conversations with anyone about this lawsuit except your attorney?
No.
And have you ever met any other witness or party to this case?
Yes, halfway down.
Can you object to work product?
You can't object to work product. It's a privilege. Anything that's a privilege, which you'll get in evidence, anything that's a privilege, that would be privileged information, you can object, and you should instruct her not to answer. Okay? If he's specifically asking for privileged information, shut it down, right? Not just objection privilege. Don't answer that question, right?
So then what would constitute as a question for work product? What would be an example?
It doesn't come up. Yeah, it would be hard for that to come up in a
I feel like you'd have to ask for
defendant's deposition. Yeah, have you seen any? Because that defendant doesn't have, doesn't really maintain any work product. Have you seen any? You know, almost anything that I can think of that would invade work product privilege would also invade attorney-client, which is a little cleaner and a little easier, right? Have you seen any notes that your attorney has taken for the case? If you're linking facts to legal theories, a witness can do that as long as you're not invading the attorney-client privilege. What did you talk about with your attorney as far as how these facts actually create the tort of battery? You have to. The example questions I can think of that invade work product privilege all invade attorney-client privilege too, and are just so contorted that you probably never hear them.
Have you met with any other witness or party to this case prior to the events giving rise to this lawsuit?
I don't understand.
Have you ever met or had any conversations, or did you know any of the other parties prior to this event occurring?
I still don't understand. Why do you ask so many questions?
That's compound. That's compound. That's a good example of a compound question. Have you ever met anybody, or do you know anybody? Have you ever seen anybody, or any of the other witnesses, or any other people, or anybody that's ever been involved, any place, anything else? So that's the kind of thing. But you get those kind of questions in depositions. Though. I find myself asking them in depositions.
Have you spoken to any witnesses who were at the bar that night?
No.
And have you signed any witness statements?
No.
Have you made any recorded statements?
No.
And have you spoken to any reporters about this case?
No.
Okay. And then have you posted any statements about these events on any internet site?
No.
Now, did you consult with any other lawyers before Mr. Butler? Objection. Privilege. It's about. So is that privilege is about other attorneys?
Depends on, it's the same question that Ryan asked before. So I think if you are, this is going to vary jurisdiction to jurisdiction, but if you're not asking about the substance of the communication, but the simple fact of the consultation, then that's okay. But when you say, did you consult about this thing? I think that does invade attorney-client privilege, and I would instruct in that answer.
Okay. And then how did you find your current attorney?
America's search engine, Bing. You almost the week.
And when you first spoke to your lawyer about this case, was there anyone else present in the room? Objection. Privilege, no answer.
Is that privilege?
I don't think it is, because it's about the presence of third parties, not the content of the discussion.
Did you hear the question they asked? When you consulted with your attorney, was there anybody else in the room? Is that privileged? Who says yes? Who says no? Perfectly proper question. Perfectly proper question. Because if there wasn't, who's at PR? Who's taking PR this semester? If there's somebody else in the room, what happens? privilege is waived, right? Unless it's a paralegal or somebody that's on staff, right? Go ahead.
So when you first spoke to your attorney about this case, was there anyone else in the room?
Yes, my mom.
Okay, and why was she attending the consultation with you?
Because she likes to tell me what to do.
And what exactly did she tell you to do?
She told me.
Objection.
What's the nature of your objection?
I'm gonna go ahead and say privilege. Shut your mouth, Britt.
Some mother-daughter privilege.
I think that's a thing.
I know you guys haven't had evidence yet, but that's not a thing. Yeah, so I think at this point, this is super uncomfortable, right? You can then get into anything and everything that was said during that meeting, and that's very, very bad for the attorney that's sitting there defending you, sort of squirming and writhing in the chair.
I wanted to make it interesting.
But it's not, yeah, there's nothing privileged about what you're talking about. This is all perfectly proper.
So just keep going.
Keep going. Yeah, Emily.
So if you're meeting with your lawyer and your spouse is there, and you and your spouse think that this attorney is representing both of you, even though only one of you is technically
That's not the scenario we have. That's different. That's not the scenario we have.
Is your mom your spouse?
That could be true. Yes. No, but either one.
Even in that scenario, would a spouse waive that privilege? Because not isn't there the privilege between spouses like when you're
It depends on the reach of the spousal privilege and what we're talking about. It's not the scenario I gave you. Anyway, go ahead.
you can't object to hearsay, right?
Cannot. Cannot. No. And you might want to do that because you're like, oh, that's hearsay. No, hearsay is totally fair game in these depositions. Totally fair game, right? If you're taking a trial deposition, you might want to make an objection on the basis of hearsay. But even then, they might just excise it. Think about how that plays out. If you're taking a trial deposition, it's with the understanding that it's going to be read into the record or played for the jury on video, right? But you'll have the opportunity to go in and excise little portions of that, take out the stuff that's objectionable, right? So you can still get into hearsay even in a trial deposition, but you make that objection, but not in a discovery day. Not really a proper objection to make. You can make it, but it has no effect. Go ahead.
So should I keep going on that line? Or
Yeah, sure. I would.
So what? I can't remember where I was.
You were invading the attorney-client privilege because her mother.
The mother-daughter privilege.
Yeah.
So
Can I amend that answer?
I wish you would just said no. Move
I like
on.
to make it interesting.
So what did your mom tell you to do?
She told me first that I'm a dumbass, and second to retain counsel.
Now, do you agree with the opinion that you were a dumbass? Objection. That's harassment.
That is harassment. It's time to shut this down. All right. Very nicely done. What do we have?
So could you ask, once the mother being in the room, did that waive privilege between Brittany and Joe?
Yes.
So you could have asked what Joe.
Yes.
What did your attorney advise you to say? Yeah.
That is the really uncomfortable.
Yeah. Okay.
Bit that you get into.
I think it's interesting.
Yeah. Okay. All right. Good job, everybody. Go sit down. All right. Where's my next 15? Elizabeth times 2. Now.
I'm not nearly as funny.
Witness takes the hot seat. She looked at way off. Sit at the head of the class.
You like dress the part?
Oh, that's because I'm going to a real depo after this.
Extra credit?
Yeah, extra credit.
For sure. That's an extra day. Okay, I've asked Allison to be the plaintiff in this deposition. Ms. Hahn taking the deposition, Ms. Mwanga defending, right? Do I have it wrong?
Yeah.
Okay. Who's the witness? You're the witness. Who's taking? You're taking? You didn't know you were taking?
No, I knew I was the question answer the question asker, but I think I formed my questions around the defendant.
Oh, okay, that's fine. You're the defendant. All right, here we go. You swear to tell the truth, the whole truth, and nothing but the truth.
Yes.
Proceed.
Hi, my name is Elizabeth Hahn, and I represent Mr. McCoy, or Mr. Hatfield. Gosh, I don't know which one's which, but I
Don't say that on the record.
Yeah. I represent
You really
Mr.
don't know.
Hatfield. Can you state your full name for the record?
Wherever you'd like to be, I think at this point. is
Okay,
fine.
James Hatfield.
All right.
Great. Mr. Hatfield, where are you employed? Are you currently employed?
No.
No? When were you last employed?
Before my face was smashed in with a glass bottle.
No, you smashed.
I thought I was the plaintiff.
I thought so too.
No,
I think she thinks
She- Oh, okay.
Right.
Yes.
So you said we switched.
Yeah.
Okay.
Can you switch and be the defendant? That's fine.
Yeah.
Sure.
Wait, hold on. Can you? She just ask again. Sorry.
When were you last employed?
A year ago.
A year ago, and where was that?
Walmart.
Okay. And why did you leave that position?
Creative differences with my manager.
What kind of differences?
Creative ones.
Can you describe those for me?
Ask the name.
But it wasn't answered.
But she said it was creative. Anyway, go ahead.
You can fight about that one on the record for an hour or two, but you're not going to get it.
Like, we'll call the judge.
For my Walmart job. Yeah, Google it. I wanted to organize the shelves differently than my manager wanted me to.
Okay.
See, that's a good example of her getting off of her outline, right? She's listening to what this witness is saying. She said, all right, well, why did you quit your last job, or why did you get separated from your last job? Well, we had creative differences with the management. And if you're not thinking about what the witness is saying, you're just so obsessed with your outline, you want to move on to the next thing. You're doing something really good here. Right? That's good. Get some good stuff out of that. All right,
were you fired?
We decided it would be best if we went our separate ways. It was mutually agreed upon.
Okay. Did you depart, was it an angry encounter? Say that. I haven't had all my coffee yet.
My manager's an asshole.
Have you previously been let go from other positions aside from that job?
Nope.
Have you ever been in any fights with anybody before?
Can you be more specific?
Any verbal or physical altercations with other people, other human beings?
That's calm
You
down.
can't help your attorney.
That's calm down.
Why would you verbal and physical?
Oh.
Have you been involved in any verbal or physical altercations with any other people? It's a little broad. Can you be more specific, right? But it's also common.
Have you been in any verbal altercations with anybody in your past?
I can't remember any specific examples, but I'm sure.
Okay. What about physical? Have you been in any physical altercations with anybody in your past?
No.
So the night in question was your first physical altercation with another person?
I don't believe I've ever been in a physical altercation.
Ryan, what do you have?
I wanted to object to form or something, because like you're asking them to conclude that you've been in an altercation, and while it's not like a legal conclusion, does the attorney have any recourse? Like, it seems like
You could lose your case.
there should be something to object to there.
Well, you've got lawyer brain real bad. So the objection you would have made would have been to what question? Question about whether or not there was an altercation at all?
About the form of about the asking
object to the form on that, but I think it's a pretty straightforward question. You could object the form, and there it is. It's preserved on the record for all time, and where does it get?
I mean, wouldn't that be something that they had already admitted, like probably already asked and admitted in their interrogatory?
Well, that could be, and
Yeah.
if you're going to depose a named party, hopefully you've already done all your written
Yeah.
discovery, and you have that in front of you, and you're going to ask them questions about it at
Right.
some point later on in the deposition. But think about it this way: if you're asking those questions early on in the deposition before you ever get to that written discovery, and you get an answer that is wildly different at the beginning than what they've said in their written discovery, that's good, right? It's good for you. Right?
Okay, so how do you cope with stress?
I have a stress ball.
Okay. Do you struggle with anger?
No, I'm very peaceful.
Do you have a history of violence?
No, I'm from a family of Quakers.
Can I object to that? Because I feel like it's kind of the same questions as have you ever been in a verbal?
I think it's a form objection. I think it's a form objection because violence is undefined. What's a history of violence? So you can make a form objection, but if she understands the question and wants to give an answer to it anyway. So it's possible. It's possible to make a form objection to just about anything. History of violence is somewhat vague, but if the witness understands it, whatever the witness understands it to mean, you could sharpen it with your objection. What do you object to form? What exactly do you mean by violence? Okay? Because we've already talked about verbal altercations. We've already talked about physical altercations. What are we really talking about? Right? So you might be able to put a finer point on it with your objection and sort of force her into a corner with your question.
I mean,
Go ahead.
Go ahead.
so if she was kind of still asking the same type of question, you know what I'm saying? Like if she refined it and it was like, okay, you're still kind of asking that same question that was already asked.
You want to make an ask and answer objection?
I mean, is it appropriate there?
Yes. I don't know that it has been asked, but maybe so. I mean, you can make the objection, but I think she's still got it.
Okay, well that's okay. We'll move on. Do you get along well with? Have you gotten along well with your coworkers in the past?
Yes.
What about your friendships? Have you gotten along? Do you get along well with your friends and family members?
These could all be form objections. That's a compound question. But getting along well, if you really want to nitpick these questions, like, what do you mean getting along well? What's that supposed to mean? How uncomfortable do you want to make the other lawyer? And how long do you want to be in this deposition? Is often the question that sort of drives these form objections.
And she still has to answer with all these objections.
Still has to answer.
I'm very popular. I have a wonderful personality.
All right. Can you tell me about your history with alcohol?
I am aware of its existence.
Okay. How old were you the first time you had an alcoholic beverage?
I think the law is 21.
But how old were you?
The law is 21. So this is legal, right? I can go 21.
Okay. And have you ever engaged in binge drinking?
What's binge drinking?
Binge drinking is okay. Well, actually, I think.
You asked the question.
Have you?
So when something like that comes up, have you ever heard the term binge drinking? What do you understand binge drinking to mean? Have you ever heard it's the same kind of stuff we were talking about with photocopier, right? In common parlance, what is binge drinking? What does that mean to you? That's how you turn it back on the witness. They ask you a question like that, turn it back on the witness. You say, all right, what does binge drinking mean to you? You ever heard that term? Have you ever engaged in anything that you would call binge drinking?
Have you ever engaged in anything that you would call binge drinking?
Does St. Patrick's Day count?
Answer that.
then you want to talk about St. Patrick's Day. Like, that's what that witness is telling you. Is like, okay, let's talk about St. Patrick's Day. Why do you bring that up specifically?
Yeah, that's good. Okay, so when you drink, what's your beverage of choice? What do you enjoy drinking?
Tequila.
And how much of it do you drink at a time? How much do you drink at a time? That's one question.
I would object to the form of that. That question's vague.
Okay.
When are we talking?
On a typical night that you drink tequila, how much do you drink?
It depends
On what?
on what day it is and what kind of mood I'm in and where I'm at and what I'm doing the next day.
Okay. So what kind of mood would you be in to cause you to drink more or less?
Happy.
So when you're happy, you drink more?
Yes.
Okay. When you're upset or sad, do you drink more?
No.
Okay. And so when you're happy and you drink more, how much do you drink?
You can object the form and then take it to your witness. Like, if you know how to answer that question, go ahead and answer it.
What was the question? How much do I drink when I'm happy?
Yeah. I'm trying to get at how much. I'm trying to get at her alcohol abuse.
Abuse. I wouldn't call it abuse. I'd call it a loving relationship.
What?
I mean, I would, if you really want to get it done. So first, I think while I'm thinking about it, for you, I think you check the form and then that sends a message to your client. That basically is like, what am I answering? How am I supposed to answer these questions? You can object the form, you can object the extent that it's vague, the false speculation, all those different things. And that, hopefully, if you prepped your witness right, that's going to send a message to her like, okay, I am going down a rabbit hole here, and if I'm not careful, if I don't ask some clarifying questions, what you're doing, then I'm lost. For you, I would walk her back through like factual. Okay, how many drinks have you had this week? How many drinks did you have the week before that? Right, and you start building and building and building on factually, because she's not going to tell you she's an alcoholic.
Right.
She's not going to sit there and say, yeah, I routinely drink way too much and pick fights with people. And I mean, no witness on earth is going to tell you
Right.
that. This isn't about maybe, but it's unlikely. So you got to walk her through factually. How much is she drinking? How often does she consume it? What do you know about? What's your average bar tab? That's a bad question. Have you been to any bars this week? How much did you spend? Okay. Jack, yes.
I was just when she brought up St. Patrick's Day, like you said, well, on St. Patrick's Day, how much did you drink?
Yeah, that's the kind of thing. I mean, you can zero. She's telling you, and witnesses will do that. I mean, they'll give you, little breadcrumbs that you can follow. Right? So she says something about St. Patrick's Day. Like, wait a minute, St. Patrick's Day must be really significant for her. What happened this last St. Patrick's Day? How did you get that?
Yeah.
Go ahead.
That's good. So tell me about the night that you went to Pizza.
I go to Pizza a lot. I like pizza. So what night?
On the night in question, on July 31st, 2016.
What happened? Is that what you're asking?
Can you describe that night?
Yes, I went to Wick's Pizza.
What time did you get there?
In the evening.
Approximately what time in the evening? Early evening?
Dusk. Around dusk. Is that 10 o'clock, 8 o'clock?
So the sun was setting. We can look at that for that day.
Sure, yeah, the sun was setting.
Okay. And did you go alone?
I went with a fan club.
What do you got?
If you know your client is perjuring themselves, what do you do like logistically? You have to be like, hey, you're
that is a PR question, and I can't go down that route. When you come to talk to me in office, you can shut it down. Is the short answer. I mean, you can pull your client into the hallway. You can stop the deposition. You can pull your client in the hallway and say, "What the hell are you doing?" But you may have to withdraw. That is a PR question, and we're going to go far beyond what I've got in 3 minutes to talk about it. Yeah.
Same thing if your client is being put in coin, right?
That's the same question I've kind of had is like she's being intentionally vague, I think, and then that's making her have to kind of keep, I guess, trying to dig, and it seems kind of
You're a hostile witness.
right, yeah.
But guess what happens when you're really doing this? And sometimes you got to just sit there as the defending attorney and just take it, because your client's super annoying and is giving giving super annoying responses because they think they're being cute with the other side or something like that. That's just part of it. And you can pull again during a break, pull them in the hallway, like, what are you doing? Just answer the question. Stop trying to be cute. For you, I like the way that you started off that line of questioning where you were, tell me what happened the night of July, whatever, and let her go. Just let her go. I mean, if that's really the kind of question you want her to answer and just get her talking, more than anything else. So don't feel like it's like an exam, like a cross-examination, right? Where you have to hammer them with question after question after question after question. She'll probably want to tell you if you just, and then what happened? And then what happened? And then what happened? What do you remember next? Okay. Get her talking. Okay, good job, everybody. Come and sign out. Thanks for helping out. This is the way it goes. You're not going to make them
Oh, Lord.
One day we don't have to all line up.
Not yet. What's up, baby? What's up, man?
Dude, what you got in there, man?
Books. I see you, man. See you in class.